Hello. Hello, mic check.
Hello. My voice is audible to you, sir?
Yeah. Hello. Hello.
Yeah, your voice is also audible.
Yeah. Yeah.
Screen is also visible. Yeah.
Yep.
Sharing is also all okay. It's 2 p.m. We can start. Madam? Achha. Hello. Good afternoon, one and all. We have with us Mr. Chirag Tanna, who is founder of Inc. D Private Limited, which is patent and trademark company. We have in our institute organized many of the IPR as well as patent as well as copyright act seminars, symposiums and other activities. But this activity should be taken little in a different way, that it will be an interactive based sort of thing. So say for instance, if you are having any case to come up with wherein you are finding a specific difficulty. So we have with us Mr. Chirag, who is expert in this all activities. He will feel himself very much comfortable to answer your all queries. So, sir, can we start? Mr. Chirag, you are comfortable?
Yes.
Since it is YouTube Live, so we'll start it. Fine. Thank you, sir. Without wasting any time, I request Mr. Chirag to take on the mic. Thank you.
Sure. So we are doing this as a question answer session, or you want me to go through the basics
please,
of IPR?
first your session will be there, and thereafter any pinpoint questions,
okay,
any
no
case
problem.
studies will be there, those will be answered.
Got it. Fine. All right. So, good afternoon, everyone. My name is, I think, Chirag. I run this firm, Inc. ID. And we do everything in intellectual property rights. Now, what are those intellectual property rights? The various acts that govern in, and what can be protected under what vertical, that I will run through in this presentation. So before we begin, what do you mean by the term intellectual property rights? So intellectual property rights is like the umbrella terminology for various kinds of verticals and various acts under these are they are implemented, and that is what is protected. So intellectual property rights basically are products of your mind which are converted into assets by virtue of law. Now, and I'll explain this further ahead. So now this property, this is an intangible sort of property. You cannot touch it, you cannot feel it, but it has tremendous value in today's day and age. You cannot, as I said, you cannot feel it, you cannot touch it, but you can calculate it, you can derive its value, or you can extract value out of it. Which is why, even though if it is a product of a mind which you cannot see, but it deserves the same kind of property protection that normal property rights deserve. So in normal property rights, what do? You go and see a piece of land, you go and see a flat, you go and see a bungalow or an office space. You measure what is the size of that flat or thing. There is a market rate, there is a ready reckoner rate that becomes the value of that asset. And then you buy that property. Before you buy that property and you own such property, you figure out whom to buy it from. So there is always somebody else, either the government owns it, the state owns it, or some other party owns it. For that, you do a title search in normal property laws. You figure out the person whom you are buying from, whether that person is the legitimate holder or not, and then you can buy that property. Same kind of principle exists in intellectual property right also. So you can own this intangible properties, which are certificates given to you by the government. But first you need to figure out whether I can own it or not. So every intellectual property right first begins with a step of searching in a particular jurisdiction. Sometimes it is all over the globe. And what are those searches? All that I'll explain further ahead. So all the concepts of normal property are applicable to intellectual property also, which means that you do a title search, then you build, you purchase, then you can sell. Once you have owned, what do? You either reside in it, or you can sell it, license it, give it to others for free, whatever you want to do with it. Same concept is given to intellectual. Once you own it, then you can practice it yourself, or you can prevent others from practicing or squatting on your intellectual property right. So all these same notions are applicable to the intellectual property rights. Now, under the ages of intellectual property rights, there are four, one of the biggest verticals that are routinely practiced. What are those four? Those are patents, trademarks, copyrights, and design registrations. Apart from these four, there are some four more: geographical indications, semiconductor layout, trade secrets, and so on and so forth. But these are four that are massively practiced. When it comes to science and technology, essentially two verticals are practiced thoroughly. One is patents and patent applications, and design registrations. So designs does not mean that you design something, but it is a property right where shapes are protected. I will go into each one of these, what is what. So cumulatively, an output of the intellect, it is intangible in nature, but can be converted into a right. The philosophy is that you disclose your right, you disclose your property or the output of your intellect to the general public. In return, the state gives you monopoly for a defined period of time. Now, every intellectual property right except copyrights is territorial in nature, which means that if you have applied for a patent within India, it is enforceable only within India. If you have applied for a trademark within India, it is enforceable only within India. So it is a territorial right. That is number one. The second is that it is a negative right, which means that if you own something, if you own an intellectual property right, does not mean that the government has told you that now you are free to practice this. It means that now you can prevent others from practicing what you have owned. So if you have come up with an invention and you have an intellectual property right certificate from the government of Singapore, let's say, that means that it is not a license for you to go and practice. It means that if anybody else does the same kind of invention and makes money out of it, you can sue them for royalty. You can get money out of such people, right? So various intellectual property rights under this umbrella terminology of intellectual property rights. If you start from the left on the screen, you will see that there is a brand name there and a logo associated with this. So logos, names, identifiers, these all are called marks or trademarks. They go under the Trademark Act. So in this case, Nespresso is a unique name. It can be protected under trademark law. Similarly, for if it's a university or a college, the name of that college can be protected under trademark law. In my instance, the name of my firm is Inc. ID, which is a pretty unique name. So I can protect that as a trademark so that no other legal firm can now use this same name and pass off whatever goodwill I have earned in the market. I can prevent others from using or squatting on that goodwill. So that's the simplest form of trademarks, simplest form of intellectual property rights. A name or a logo can be protected and it is associated with a business that you provide. Especially for if we're talking in the context of startups here, then the simplest but the most powerful form of intellectual property right is trademarks. And whether it is technology or non-technology or creative startup or whatever it is, the name identifier is the bare minimum intellectual property right asset that one can own. If you move a little towards the right, you will see that there is a milk frother. Now, if I have to protect the shape of anything, now the shape of anything means the shape of a frother in this case, or the shape of a mug, or the shape of a bottle, or the shape of a telephone. Apple basically they changed the entire shape of a phone because they came out with a rectangular phone with rounded corners. This is way back in 2008, 2009, and one button. The entire Apple versus Samsung war was based on design shapes. That Samsung began copying the designs of iPads and iPhones that Apple had first invented. So if you have to protect the shape of anything that is unique, then design registrations come into play. Again, this is one of the very simple forms of intellectual property rights, where the only thing that you submit to a designs office is various views of a product from various sides, so top, bottom, left, right. And in return, you get a protection for this. One of the most common but most effective, but most debated, hotly contested, but in the field of science and technology is something called as patents or patent applications. So anything to do with science and technology, if you are solving a technical problem in a manner that nobody else in the entire world has solved, and you are getting an advantage which nobody in the entire world is getting, then you can embark upon filing a patent application. And for the most part of this talk, I will focus on patent applications and how are they assessed across the world. It's one of the most challenging things, but it is one of the most litigated forms of intellectual property rights also. Um, Moving on, if we move on from technical content and scientific content, if there is just creative work to be protected. Now, creative work means if you have written a book or a novel, if that needs to be protected, if there is an artwork that needs to be protected, if there is a musical notation or a song or a cinematographic work that is to be protected, that goes under Copyright Act and it is protected by copyright law. So in this case, the entire artwork that you see as a layout or maybe a brochure here, the entire content, this graphical illustration of the Nespresso machine along with the frother and everything goes under Copyright Act. Then there is something called as trade secret, and we'll talk about that later or maybe sometime in the future. But trade secrets is something that you keep confidential. It goes against the philosophy of intellectual property rights. The philosophy of intellectual property rights states that you disclose what is the product of your mind or whatever you have created, whether it is a brand name or an invention or a specific design or an artwork or a musical notation or a song or a movie. You disclose that to the public. In return, you will get a reward, which is a monopoly, such that you can prevent others from using that same concept. Trade secret goes a little away from that, whereas you can keep a trade secret within your own organization. Biggest example of this is, let's say, Coca-Cola recipe. We have had so many of black drinks which are fizzy and varying tastes, but the exact taste of Coca-Cola, nobody has been able to reverse engineer because they have a mechanism in place where they can keep that recipe as a trade secret. Right? Another example, if I have to give you, of various types of intellectual property rights in a single ecosystem is, let's take the word, like the company Kodak. They make cameras and films. So the name Kodak is unique here, which is why it can be protected under the Trademark Act. So nobody makes films and cameras with the name Kodak except the company itself. Or you can take a license from the company saying that, I want to use your name. You can give them X $100 million or whatever they ask, and then you can use their name. So brand names of Kodak get protected under Trademark Act. The packaging, the artistic work on that packaging goes under the Copyright Act. The camera body has to be pretty sleek. It has to be ergonomic such that the fingers are placed properly, the lens is adjustable and things like that. So there the shape comes into play of how you have made the shape ergonomic to use or sleek in design. All that can get protected under Designs Act. The internal working mechanisms of that camera, which is the shutters, how the shutter works, how light capturing works, how focus works, each one of them can become an independent subject matter of a patent application. So a single camera can probably be covered by hundreds of patent applications. Similarly, if you take mobile phones today, every mobile phone is covered by at least 1,000 plus patent applications from a variety of people. If you take Apple's phone, they will have certain patents. Then the chip guys who are supplying them chips will have certain patents on it. Then the 2G, 3G standards, the telecommunication standards, which allow anybody in the world to talk to anybody in the world over a defined spectrum, can become a separate set of patent applications in the telecommunication space. Again, the cameras inside a phone, how they focus, how are their lenses placed, all that can become a separate patent application in the phone domain. So single phone, audio, video, so many thousands of things happen in a phone today. Every phone is covered by at least 1,000 plus patents, which are inbuilt, which are by the company or licensed from other players in the ecosystem of telecommunication. Right. Then, as I said, there are some more things here. The literature can become part of Copyright Act. The printed circuit boards, there is a separate act almost in all countries where semiconductor layouts per se can be protected. We don't make chips that much. That is why semiconductor layouts are not protected in India that much. The film coating process, if you can keep it as trade secret, then comes under the Trade Secret Act. Right? India does not have a Trade Secret Act, but generally many first world countries have a Trade Secret Act. Right? Similarly, one last example I can give you. On the left, you see TVS as a logo and TVS as the name that can go under Trademark Act. The engine, everything to do with the engine, the ignition of the engine, the shock absorbers, all that has to do with science and technology of how to burn fuel, how to improve the efficiency of fuel, how to have low carbon emissions, how to improve mileage. All those become advantages of the workings of an engine. All that can become separate patent applications. Uh, a very big case here in India was TVS versus Bajaj, where Bajaj had invented a twin spark plug, and they had sued TVS and gotten away with making them stop production of their bikes for a long period of time. It was one of the landmark cases in the Indian patent scenario some 10 years ago, right? Then the artistic work of how flame is written, this entire artwork can go under Copyright Act. And the ergonomic, the entire shape of the vehicle or the chassis can go under Designs Act. The ergonomics of just the seat itself can go under Design Act. The ergonomics of just the headlight, all those can go under the Design Act, right? So four basic forms of intellectual property right which are routinely followed. So trademarks, essentially, what did they do? They protect a name, a brand, or a logo. Once you have that registered, you can own them for life as long as you remember to renew them every 10 years. So you need before the end of 10th year, you need to go to the trademark registry, pay renewal fees, and you get an extension of another 10 years. But basically, you can own a trademark for life. Patents have a finite life across the world. Once a patent is granted, the right given to you is 20 years, not from the date of grant, but from the date of filing. So patent office can take 2, 3, 5, 10, 15 years also to get a grant, but the right will still date back to the date of filing of the application. The only exception to this rule is the United States of America, where if the patent office has taken a longer period of time to grant to get your application to a grant, then they add on years to the life of a patent. But for all practical purposes, it is 20 years from the date of filing. Copyrights, basically it's life of an author plus 60 years. So the heirs, at least two generations of heirs of that author can enjoy royalties, if any, even after the author has passed away, if there's a good copyright application in place. And this becomes very important in the music industry, in Hindi cinema. Basically, it used to be life of an author plus 20 years, but India played a very important role in bringing it from 20 years to 60 years. Basically, Shanti Niketan wanted to protect the works of Rabindranath Tagore for a long time. So they lobbied, and now the entire world follows this principle of life of an author plus 60 years. Copyrights is also unique. If you remember, I told you that every form of intellectual property right is a negative right. And the second thing is that every form of intellectual property right is a territorial right. So what that means is, if once you get a certificate, it is valid only in a particular jurisdiction. If you want, you can pay other countries' fees, prosecute in those countries, and get those other jurisdictions also under your belt. But copyrights is unique because one copyright application is valid across the world. Another unique thing of copyright is that you don't need to register it. Every other form of intellectual property right, in order for you to own it, you need to go to that respective office. So if it is trademarks, you go to the trademark registry. If it's designs, you go to the designs office in Calcutta. If it's patents, you go to the patent office in one of the 4 metros. The copyright office sits in Delhi, but it is non-statutory in nature, which means that if you have created something unique, automatically it is your copyright. You don't need to go and show that to the world. But the copyright mechanism exists to make it easier for it to show it to the world, to make it easier for you to show to a judge if in cases of infringement. So tomorrow, if you are a musician and in your own bedroom you have created 10 songs and recorded a CD, it is still your copyright. But the world hasn't listened to it. So how will you ever prove? Let's say if some production house in Bollywood copies your music somehow, and then there is no way for you to prove that this was your music, you created this on such and such date in your bedroom and things like that, which is why the copyright mechanism exists, that you can file it with the copyright office, get a certificate and return, and then if there is infringement, it makes it easier for a judge to decide that whether there is infringement or not. Right? Life of designs where only the aesthetics or the shape is protected is 10 years. You can buy 5 more years. So another thing that you need to remember, if it is in the realm of science, technology or something like that, if you need to protect just the shape of something, then it goes under designs. If you need to protect the construction, logic, working, functioning of something, then it goes under patents, the bucket of patents, right? Beyond this, I told you there are some more not routinely practiced intellectual property rights. So geographical indications is one, plant variety is one, semiconductor layout is one. I will leave that for now because that's another trail of thought. Right? Now, those 7 that you saw earlier are formally registrable intellectual property rights. Beyond that also, in a company, there is something called as informal intellectual property rights, or something that you cannot register. So trade secrets are one, where secrets of how a company functions, secret recipes, all those things can be protected under trade secrets. So quality of a code, there is no way to judge if you have written software code, if anybody has ever written software code, there is a certain quality of how you write a code. So all that goes under informal intellectual property rights. The formation of a company, how you do your business dealings, or what is the internal hierarchy of an organization, how it behaves with other companies, all that goes under informal intellectual property rights. So, and the formal property rights can be valued by some mechanism or the other. Informal basically cannot be valued as such, but it exists. The point is that is also a form of intellectual property right, which exists and contributes to the growth of an organization or of a company. Right. So if we move on to patents per se, what are patents? So these are certificates. On the left and griddle, you will see how a US patent looks like and how a US patent certificate looks like. On the right, you will see what an Indian granted patent certificate looks like by the government. Right? So in the realm of science and technology, most of us, especially at the master's level and PhD level, we have seen, we have more or less kind of invented something. If you have written a decent master's thesis, or if you have written a decent PhD thesis, you have sort of contributed to the advancement of science, what does it mean? That you have probably invented something. If you have invented something, you need to know now how to protect that invention also. Up until now, in the university culture in India, what people would do is just go and publish their research articles in peer-reviewed journals. And people would think that there is credit given, which means that you are now credited with what you have created. But the buck does not stop there, because now you have made it available to the public. Publications do not give you anything in return. It does not allow you to own something. A precursor to publication now, therefore, is that you protect something by way of patent applications and then go and publish it, right? So the most important, again, the most important thing for what can you own? So there you need to understand 3 things: invention versus discovery versus rearrangement. Before that, you need to understand 3 things, that what can be protected under patents. So there is a technical problem that you're solving, which is why you are doing what you're doing. There is a technical solution that is a product of your mind towards that technical problem. And there has to be a technical advantage to that technical solution and technical problems. Because if you don't have that advantage, then the question always will be, why are you then reinventing the wheel? If the wheel was known, what is your contribution in advancing the limitations of that wheel? So these 3 things, while embarking on a patent application, these 3 things have to be absolutely clear. If anything is missing here, then chances drastically reduce in getting the patent to grant. So these 3 things have to be very clear, right? The definition of a patent act, according to, I mean, most patent acts across the world, is that it has to be a new product or a process, which means that you have to figure out whether you have your solution, does it, is it targeted towards a product or is it targeted towards a process? Now, products essentially, if it is in the engineering fields, if it is mechanical, biomedical, software, generally it will be a product. Processes mainly will be in treatment of material or chemical processes. You know, mechanical engineering generally won't have process patents. Automobile engineering generally won't have process patents. All of those would be under product patents. But a new product or a process basically having an inventive step. Now, what this inventive step means is also defined theoretically in the Patent Act, that it says that it is a feature of an invention that involves technical advancement and blah, blah, blah. But this is something that is argued day in and day out everywhere in the world, even today. Now, Indian Patent Act took birth in 1970, but you go back 200 years, the US Patent Act took birth in 1790. So they have a 200-year-old history of patents and patent litigation and enforcement and assertion and all that behind them. Even then, even today, what is patentable over something that was previously known is argued day in and day out in the courts of law. And the reason is very simple, because there is a very well-known saying in the English language which says that hindsight is 2020. So the moment you script it down in terms of a patent application, it automatically seems obvious. But you cannot apply hindsight analysis while evaluating a patent application. And that is the fight between you and the patent office. That is the fight between you and a judge, if you are going to come to enforcement, of whether hindsight analysis was uh, applied or not. And then there are a whole bunch of series of tests to evaluate how to make this subjective analysis into more objective analysis and things like that, right? But across the world, the entire world has agreed that a patent should be evaluated on three basic criteria: novelty, inventive step, and industrial application or utility. If I have to rank these, or if I have to give marks out of 100 for each of these tests, I would say that novelty and utility basically contribute to only 5 marks out of 100. The entire 95 marks out of 100 I would give to inventive step, right? Because it is very easy to establish novelty, it is very easy to establish utility, but inventive step is the toughest to overcome. And why is that? I'll show you again by examples. If your invention is A plus B plus C, right? And remember I told you that you need to do a title search to own any intellectual property right. So if you are filing for a trademark application, you need to do a search to see if whether that word, let's say ink ID is the word that I want to trademark in terms of legal services. I need to do a search within India because I have an office in India. I need to do a search within Singapore because I have an office in Singapore. Whether this name is owned in the field of legal services by anybody else. If yes, I cannot own it. If not, then I can own it. Now, this search is country-wise. But in patents, this title search is global in nature. Now see I'm not sure irony is the right word. The protection is territorial, but the search for patents is global in nature. And the reason is because you are contributing to an advancement in science. Science does not have geographical boundaries. Like you cannot say that this is a science of India, or this is the science of China, or this is the science of Korea, or this is the science of Afghanistan, or things like that. Science does not have any geographical barriers. And you are contributing to an advancement in science by way of a patent application, by way of an invention for which you want protection by way of patents. Because science does not have geographical boundaries, the search has to be universal in nature. You have to search for everything and anything that is there on this planet Earth known to humankind. As long as it is documented, you have to search and tell the patent office, or the patent office will tell you that this was known. So coming back to this slide, if A plus B plus C was your invention, and if there is any sort of literature in the world in any language which talks about A plus B plus C in theory, then you cannot get a patent application. Now to overcome this is very easy. You can add M to it, you can add N to it, you can add Z to it and say, okay, A plus B plus C was known, but now I've added more things which were not known, and now it is novel, which is fine. It is very easy to overcome. The real challenge comes here, let's say now that was one document. If there are two documents now, if your invention was A plus B plus C, and there is one document in China which talks about A plus B, there is one document in Japanese language which talks about B plus C, and all you did was join them together. Maybe you are the first person in the world to join them together, but you don't have an advantage. Your advantage is limited to advantages of A, B, C, AB, and BC. There is nothing advantageous over and above that. That means that you have novelty, you have industrial applicability because maybe it is used in industry or it is repeatable, but you do not have inventive step because anybody could have joined them together. The fact that nobody in the world joined them together is not an excuse to overcome objections relative to inventive step. The only way to get now introduce inventive step into this scenario is by showing this B dash. You have to show to the patent office that why did anybody not join them together? What was stopping them? What was that one missing piece of the puzzle that was an output of your intellect that allowed you to now join A plus B and B plus B together, which is that B dash. And now that B dash is contributing to inventive step. So novelty was very easy that you join them together, but B dash now allows these two things to talk together. One very simple example of this is, let's say if there is a bucket which holds water, you put a clock on it. You cut a circle on that bucket, put a round clock on it, and now you have a bucket which holds water and shows you time while having a bath also at the same time. You don't have to look here and there. It is novel. Maybe nobody in the entire world joined them together, which is fine. Maybe nobody had the need to join them together. It has utility also. It is industrially applicable because you can repeat this 10,000 times. So novelty is there, industrial applicability is there, but inventive step is not there because anybody of ordinary skill in the art could have cut a circle and put this thing onto a watch onto it, which means that inventive. Now, how do you make this inventive? The way to make this inventive is to show that both are interdependent on each other, which means that either the working of the clock is related to storage of water, which is not possible, but you can show that maybe the manner in which water is filled in the bucket allows the clock to work. And there is actually a device which does that. As long as you show a synergistic effect, that is another thing. If you can show a synergistic effect, and now you have an advantage which is over and above the known advantages of bucket and water, because now you have the working or the flow of water driving or powering the watch, which is an advantage over and above the known advantages of each of its individual elements, or now the sum is more than the each of its constituent parts, then you can have an inventive step, and then you have a real chance at getting a patent application. So this is what the patent office always looks for. What is that B dash? Why was it missing? And if once you start working or engaging formally, you will see that the entire story or argument between you and me will be to find out that B dash and to present that in the most crisp, clean, and clear manner to the patent office, right? And rearrangement is also, this is just one slide where you show that, just rearranging data or rearranging, especially in the realm of software, classification of data and all those things are not patentable. You have to show that there was a technical problem, there is a technical solution that was solved, and you did that because there is a technical advantage. You just didn't do it because you wanted a different thing to it. Biggest example, again, I'll give you, okay, before that, let's talk about one other thing that the patent office checks is concept versus enablement. You cannot get patents for theoretical ideas. So biggest example again is you cannot get a concept for patent for flying. Wright brothers, we say that they invented flying for all practical purposes, but the concept of flying was known in birds earlier. The concept of flying was also known in people who were working on flight mechanisms before the Wright brothers. But what they did not achieve was two things before the Wright brothers. Two things were not achieved. What was not achieved was sustained flight over a long distance was not achieved. That is what they solved. And the other major thing that they solved was changing path mid-flight. So in air where friction is very less and it's in a 3D environment, how do you change flight mid-course? Because if you're not changing your flight curve mid-course, then all you would do is just travel in a straight line, and that would again be pointless. So these guys came up with a device of wing warping, where you inbuild inherent instability in a stable flight, which allows you to bank and turn. And that device was what was patented by the Wright brothers, and they got a patent in around 1903 for that, and that lasted for 20 years. And then there was improvement, obviously, over that. And today's flight control mechanisms have another mechanism for that flight control. So concept of flying was not owned by anybody. One mechanism of how you could fly can be owned by someone. Similarly, let's talk about data transmission or telecommunication. Concept of data transmission or telecommunication over a 2G standard cannot just be owned. One way of doing that can be owned by somebody. Similarly, you take in today's, you fast forward from this to Uber, Ola today. What do you do in Uber, Ola? Earlier, what would happen before Uber and Ola? You would go out onto the street and shout taxi, taxi, rickshaw, rickshaw on the road. And instead of that, now it started becoming more sophisticated. You don't have to go and shout on the road. You can sit in the confines of your room, look at an app and just press a button, and a ride comes to you. So these are ride hailing apps as such. So what they did was a simple concept, right? They took a signal, your signal, GPS signal, which is read by your phone at all times now, and they crossed that signal with 3 or 4 moving objects, which are cabs or cab drivers around you, and gave you the best possible 2 or 3 combinations of hailing a ride in front of you. So that concept was not owned by anybody. Because if that concept was owned, let's say by Uber, which is one of the former companies, you would not have had Ola, you would not have had Lyft in US, you would not have had Gojek or Grab in Indonesia and Singapore and things like that. So which means that abstract ideas cannot be protected. The level of degree of detail of how it is plausible and possible has to be detailed out. So even though when I say that Uber, Ola cannot be protected by patent applications, what you see here is a 2003 application when we did not have smartphones, when we did not have GPS on our phones. This is the level of degree of detail by an American inventor in 2003 who had then disclosed to the patent office of how people would hail rides in the future. So if you have this level of disclosure early on, even though you have not built a product, you can get a patent application around it, because all other things were there. There was a technical problem, there was a technical solution, and there was a clear technical advantage. Beyond that, again, there are certain things which are not patent eligible. There is an entire section in the Indian Patent Act which are not patent eligible, but basically it revolves around this. So games are not patent eligible, business ideas are not patent eligible, methods of doing surgery are not patent eligible, but devices which allow you to do that surgery are patent eligible. And there is an entire section around that. Mathematics cannot be patent eligible. But if you use that mathematical formula in something tangible or create an algorithm out of it to do something useful, then you can have a patent around it. Basically, this is just a sample of what cannot be patentable. Technical advantages, again, we can, but these are just some examples of technical advantages. Going back to the definition of inventions, what can be protected is product or a process. That has to be very clear right from the word go. Under this, there are 4 more things. If you have to go one step below, it can be a process, which is an act or a series of steps that you can protect. There is a product, which is a machine, which is the parts and certain elements talking to each other and giving an output which was not previously known. That can be protected under product patents. A method of manufacturing something. So like, let's say heat treatment of steel to be used in transformers. That can be patent protected. Or composition of matters. Now, if you take pharmaceutical products almost always will be protected by 2 things. One is the composition. So X percentage of ingredient A, Y percentage of ingredient B, Z percentage of ingredient C all come together to make a pill, which allows you to control blood sugar. composition of that matter can be protected in chemistry or pharmaceutical applications, and the method of arriving at that composition, the process steps, point number one, of doing something to ingredient A, then adding something to ingredient B, and then mixing B and A to in certain proportion with a certain solvent. All that sequence of steps can go under process patents. Beyond this, nothing can be protected. So that is not important of what can be protected. This has to be very clear in your word, right from the word go, of what you are trying to protect. What is your output? Which is why when you start talking or writing a patent application, or you start talking to somebody like us, we start working reverse. We figure out, okay, what was your output? First let's define the output, because the output is what we are going to protect. How did you reach that output? What was the input that you defined? And then how did you reach from the input to the output? For that know-how, you get a patent, because that know-how is the enablement or the output of your idea, which is an enabled concept. And even after all this, you have to show that now this output has an advantage that was not previously known in the entire world. But you start working reverse, basically. Figure out the output, then figure out the input, then figure out the black box in between that allowed the output to be transformed into the input. Then you start embarking on a good patent application, right? So why do we do all of this? As I told you, right? All types of intellectual property rights are negative intellectual property rights, which means that if you own something, you have the yellow picket fence that you see, you have a good picket fence around it. Anybody, of course, you can practice it, but that is not the right that is given to you. But you can prevent others from doing it. If anybody else now as an institute or of higher education or education, it is important that you license your technology to others, because what will you do with just a stack of certificates, right? So you can license it out to industry and in return get money from it. If there is somebody who is voluntarily or even involuntarily traversing your domain, then you can sue them in a court of law. Patent office does not take part here. You have to go to a high court or a district court, and then they will evaluate whether what you have written, what is your protection, whether they're actually infringing or not, how long they have been infringing, and they can give you a certain monetary reward from it. Almost always there will be a green path. There will be an alternative mechanism uh, for somebody to practice. But a good patent draft ensures that this alternative path will be of lesser value or will not have as much advantages that you are providing if somebody were to travel the blue path. Right? So that is the idea of having a good patent application. Why do you patent? Basically, these are all, for startups, this is essential. That it's an asset that you create for licensing, selling. It is a negative right, so you get protection. It is a form of recognition. In certain countries, you can get insurance. You can get a loan where, because it is a form of property, like how normal property you can mortgage and get money in return at a specific rate. In countries like US and Singapore, you can mortgage your intellectual property right and get a loan in return as well. An inventor can file for a patent application. An inventor is somebody who is generally dissatisfied with the existing reality, which is why they have created something new. They are continuously solving problems. They are continuously figuring out what is missing somewhere and try to give out a solution which is an advantage to humankind. But basically, these are people who have advanced the realms of science that is penned down by patent applications. And so an inventor is somebody who has to be credited in the patent application. The owner can be somebody different. So in the case of a college like yours or a university like yours, the university can own everything. They have all the rights of what to do with the patent application. But there will be human inventors who have to be credited with solving a certain problem. Animals cannot be credited with solving problems. The whole world now is fighting where can softwares be credited with solving problems, because we have reached a stage where softwares are creating new softwares, and lot of advanced jurisdictions are fighting, saying that no human was involved and things like that. So that's all a separate story. When to file, again, this is very, very, very important. The first step, the moment you think that there is a technical problem that you're solving and you have a solution towards it, you must go and file a provisional patent application. before any other disclosure. You cannot, before any other public disclosure, you can talk to your peers and things like that, but you cannot publish it on your website. You cannot publish it in a peer reviewed or any journal. You cannot write it in a book. The moment it becomes a publication available to the general public, the buck stops there. You cannot then go and file a patent application. You cannot go and tell the patent application, but I am the author here of this journal. So what, I filed this later. This is my own invention. All these arguments do not work, right? So the first step as an institute or as HODs or things like that, if you think that there is something worth owning, must go and file a provisional application. Then you can go and shout on your rooftops or publish it on your websites or file in peer reviewed journals or just write in some thesis and things like that. But the first step has to be a provisional patent application, right? Now, how the title search that I said, you need to do searches to figure out what are the novelty destroying documents or inventive step destroying document. So there are freely available patent databases across the world. These are just some examples. There is Patent Scope, there is US Patent website. Every patent office in the world has their free server, for their free engine, where you can figure out what was filed in their country. Okay. Now, this is European Patent Applications, European Patent Office's website. Although it is Europe, they poll data from 90 plus countries. So this is a good free resource to search whether there are any other patent applications around it or not. These are just some examples of what happens once you do a search. You can see everything around it once it becomes available to the public. Who filed it? Where was it filed? What all other countries was it filed? So it gives you a sort of strategy also for filing in foreign countries and things like that. Right? This again important slide where it tells you the timeline. Right? So stage one is your light bulb moment, your idea stage. As soon as possible, go and file a provisional patent application if you think that this is feasible. Now, for namesake, we have written here 5 to 10 days, but generally you can, it can be up to a month or something like that. Once you feel that this is something worth investing in terms of time, effort, energy, money, all those things, stage 2 must be established very quickly, because this is the document that will tell the world that you have invented something on such and such date. In this document, you have laid down the technical problem, the technical solution. Those technical solutions can be one or more, because at this point of time, you have not figured out what is the best way or that this would work. So you can have multiple solutions here and the advantages here. So it has to be, again, not abstract. It has to be an enabled concept that you file here. But you must remember that once stage 2 is established, the clock starts ticking. Within 1 year, it is a hard stop. No amount of money can stop this. But within 1 year, you have to complete stage 4. So within 12 months of filing the provisional patent application of stage 2, you have to define the picket fence, the yellow picket fence that I showed you, the boundary of your invention. So you have to show working examples if possible. And then there is something called as claims, which is the definition of your invention. So whether you write a 10-page patent or whether you write a 300-page patent, it all comes down to one single sentence that you write that defines your complete invention. That is called claim 1. I will show you one patent example. And claim 1 is what defines the boundary of your invention, the techno-legal boundary of your invention in words. The patent office or a judge, if you are in a court of infringement, does not see what you have invented. It does not see a physical apparatus. They will only see the words that were written in the patent application, and specifically in that one line definition that you have written as the boundary, which is called claim 1. That has to be defined at stage 4. Once that is defined, you are locked. You cannot add more subject matter to the patent application later on, right? So if there is a piece that is missing, but you have figured that out, okay, there was an element A that I should have added, you cannot add that. No amount of money will allow you to add more subject matter after stage 4. The stage 4 is the most crucial step. After that, and only after stage 4, the patent office touches your application. Till this point of time, they have not even seen your application. Once you complete stage 4, then the patent office opens your file. It checks whether it matches what you had written 1 year before in stage 2. Otherwise, they will tell you that whatever you had written 1 year ago does not correlate with this. So we are not going to give you that honor that filing date. If everything is in good order, they will process. And then they will embark on those 3 steps of patentability opinion. That is novelty, inventive step, and industrial applicability. And they will give you an opinion on each one of these 3 and then tell you that, okay, we think that this is novel, we think that this is not inventive because there are 2 documents which we feel talk about, if they are joined together, they talk about your invention, which is where then your argument with the patent office starts, where you tell the patent office that, okay, no, document A has certain elements that are missing, document B has certain elements that are missing, which are now there in my patent application. And the combination of this, still there is something missing, which is there in my patent application. Once that back and forth with the examiner or controller happens and you have satisfied the queries of the patent office, then if everything is good, it goes to grant. In India, almost always it's a 2-step process. First is the examination report, which is reply to examination report, where an examiner examines everything. And then it goes to a controller who is the superior person above him, and then they sign off. And the controller does all this in a video conference hearing or a physical hearing, where they understand the entire subject matter. They see what all other documents were cited, whether you are still an improvement over those citations. And if yes, they will give you a patent certificate. This entire journey in any part of the world today takes between 3.5 to 5 years or 2.5 to 5 years. India currently is the fastest in the world, where we have reached the stage of examination, that is stage 7. Within 1.5 to 2 years, we can reach that very quickly. There is some delay between stage 7 and stage 8, but that will also be addressed very, very soon. There are examples of how other people's, if I will just give you a quick example, like the importance of filing, right? The whole world believes that Graham Bell was or is the inventor of telephones. But there was this one other person, if you search and read about him on Google, I mean, through Google and Wikipedia, you'll see that there was this other gentleman called Elisha Gray, who was getting far more better results in communication over a wired medium, communicating sound over a wired medium than Graham Bell. When Graham Bell got wind of the fact that, Elisha Gray is now going to go to the patent office tomorrow to file his patent application, they rushed up an application pretty quickly, and they both reached the patent office the same day, and during the same lunch hour, to be honest. It's just that this Graham Bell's attorney was a little mischievous or devious, and he bribed to get his application filed before in time than Elisha Gray's, which is why the world credits Graham Bell with the invention of the telephone, even though Elisha Gray had far better results than Edison at that point, than Graham Bell at that point in time. So the importance of filing a patent application, who files first, is very, very important. You talk about this is probably 100 years ago, but even today we are fighting cases in the US where the difference between 2 filings for the same kind of technology is 19 days and 9 days and 1 year, 4 days and things like that. So the first step of filing is very, very crucial, right? If you take the example of Apple, Apple had to shell out a lot of money in 2001 when they came up with iPad, because some technology was copied from Creative. At that time, Apple was not very IPR prolific. It wasn't, a lot was not invested in IPR at that point in time. But then that is when Steve Jobs said that nothing doing. They had paid $200 million to Creative at that point in time. They said that everything that happens in Apple right now will be protected by way of patent applications or intellectual property rights. So the box in which an iPhone comes is protected by design patents. The shape of the iPhone is protected by design patents. Of course, there are thousands of patents technical patents that are filed there. But simple things like the store layout is protected by designs. The store layout is protected by something called as trademarks also. The entire glass staircase, if you have seen an Apple showroom, is protected by designs and patents and things like that. So that is the extent to which IP is valued in an advanced country and monetized, not just valued, monetized also by countries like US. Right? I think we can stop here because then this is just trademarks, and trademarks is not, I mean, it's just where marks are protected and things like that. These are just different kinds of trademarks that can be protected. Colors as trademarks can be protected. Logos can be protected. The only thing to remember here in trademarks is that it has to be a unique name. It cannot describe what you're doing. So if you're making biscuits, which are salty biscuits, you cannot call them salty biscuits. If you call them Monaco, then it's a unique name. Then you get a trademark for it. And the other thing to remember in trademarks is that it is based on the goods or services that you provide. So across the world, this is a classification that that they follow. So if you have created an app, class 9, so this is just an example list. There are many other things under this list. So class 9 would be mobile applications. You would protect under class 9. Class 42 is software as a service. You would protect under class 42. If you're opening up a restaurant, you would protect that under class 43. If you are opening a t-shirts business, then you would protect that under class 25 and class 35 and things like that. So what does classification means? That every class becomes a separate trademark, which means that you have to pay separate fees to the patent office. So a trademark application for the same name in two classes would mean 9,000 rupees, because every trademark in terms of government fees is 4,500 rupees. Right? And it goes to a similar process. You search, you file an application report, file an application, then the trademark office examines it to see whether it is distinctive or not, whether it is similar phonetically. Just changing spelling names does not help. If it should be such that you are not causing likelihood of confusion in a specific domain, right? And then if everything is good, it can go towards certification. This is trademarks, and then copyrights. I explained all types of artistic work can be protected, or creative work can be protected under copyrights. This is cases, and in designs, shapes, etc. can be protected. So these are various examples of shapes that can be protected. Surface patterns of rugs. The biggest filer of designs year after year is Sabyasachi, who creates unique saris in India. I can stop here and we'll take questions.
Hello, am I audible?
Yeah. Yes, ma'am.
Yeah, it's a nice presentation. Actually, for the beginner, it is beyond our expectation. Thank you very much.
Sure.
Now, I request my faculty members, they are having numerous questions. So let us discuss one by one the questions. That will be the better way of
Sure.
analyzing the session. Anybody? All the faculties are requested to come forward, because ultimately you have to file the patent. At that time, you will not get any support. Right now, the support is available with you. Yeah.
Sir, in provisional patent application, what degree of information must be disclosed? If we are having any preliminary idea, can we file a provisional patent with minimum number of documents?
Not really. It has to be, you have to show that it is a plausible idea, and as much as possible. So as long as that germ of the solution is there, you are able to show that inventive step. It cannot be just theoretical. So that's a judgment call, but it has to be an enabled idea. It cannot just be abstract in nature. So mere concept cannot file a provisional patent application. You can file it, you will get you can even file poetry and get a application in number, but once you file a complete, it will be discarded. It won't be honored by the patent office. And then it will be too late. So
Hello.
yeah.
Sir, this is Dharmen Singh Yadav, and you have mentioned 7 stages of patent filing, And I have seen in your site there is a optional stages. Can you elaborate these stages also?
So two optional steps maybe. One is a patent, once you file a provisional, uh, it does not immediately become available to the public. If you have filed a provisional, it becomes available to the public only on two conditions. One is you have to file a complete. If you don't file a complete, it is automatically abandoned and never published or made available to the public. And the second step is you have to wait for 18 months from the date of filing of the provisional. After that, it becomes public. Now, sometimes what happens is that some people have not filed a provisional, they have directly filed the complete. So then why would you wait for 18 months? Because then you have not utilized the 12-month period. So that optional step is filing for urgent publication, where you pay extra fees to the government and tell them that, okay, publish my application within one month's timeline. Don't wait for 18 months. So that prosecution of your application gets reduced by 17 months in that case. That's option number one. The option number two, branching off, is foreign filings. So at the end of 12 months, you need to decide the countries that you want to file in also. So and that depends on how you are going to monetize the patent. So that is when then you start branching off. You directly file in foreign countries, or then there is a separate mechanism where you file an application with WIPO. WIPO is World Intellectual Property Organization. It is located in Geneva. It is basically the overseeing body of all IP offices of the entire world. So you pay $1,500 to that organization, and you lodge that application, and then you buy 18 more months over and above the 12 months of provisional to complete, and then file in foreign countries. So that foreign countries clause remains, but that's the other option. You can file it with WIPO, because in 12 months, even if you are like the Tatas or Infosys or Wipros or TCSs of the world, nobody has that kind of money to go and file in individual countries, because 12 months just blink and go by. It is impossible to, even if you have the money, it is impossible to figure out where all you want protection. So that's the option number two.
No, sir, 4.5 years is too long period. Is there any process to reduce that period?
There is in India and Singapore and USA, there is a fast track mechanism. And universities now in India, if they are state affiliated or center affiliated, they can avail an option. They can pay some 6,500 rupees extra to the government, and it will get processed in 1 year.
Sir, what is the fees for filing the patent?
Government fees, first step of filing is 1,600. Then anytime within 4 years, you need to pay 4,000 rupees as request for search and examination to the patent office. But those are the statutory fees. The main fees are patent agent fees or the drafting fees. It's a 5-step procedure: provisional patent drafting, prior art search, complete patent application, reply to examination report, attending a hearing, and replying, making written responses after that hearing. So each of the 5 steps, generally in India, attorneys charge anywhere between 15,000 to 35,000 Indian rupees for each of these steps. Now, we work in a different model with startups and institutes. We reduce that to 2 or 3 steps so that it becomes compact and the burden is reduced.
Hello, sir.
Hello.
For having the medical device IP strategies, there are 5 stages. Which stage? The concept stage, prototype stage, preclinical, manufacturing and marketing, and which stage we should actually go for patent?
Prototype. Definitely prototype. Just before, and generally how it happens is there will generally be 2 or 3 prototypes at that stage. The moment you have created like a first working model, even if it is a basic paperclip model or things like that, you should file a provisional.
So
because otherwise then you run the risk of leaking to others, or almost always you will see, there used to be a series on Amazon, I don't think it's there anymore. You will see that any invention, I gave you just one example of this thing, telephone. Take any landmark invention in the world, And you will always see that there are two people in the world who are working towards that exact same problem.
Okay. So it will take almost 3 years in India if you're going for national patent. So within the 3 years, we should be ready for the marketing stage to have it.
No, that has got nothing to do with this. These are two separate parts.
Okay.
A patent is a right to prevent somebody else. It is not a right to practice. So the patent office does not care whether the model is there or not, whether it works or not, as long as you can prove in theory that it aligns to the known laws of physics, chemistry, biology, other sciences and things like that, you can get a patent for it. But it has got nothing else to do with this. It is better that if you're talking about monetization and startups, it's better that they go hand in hand, because feedback that you get from the actual market feedback can be built within that 1 year period from provisional to complete. Once that is locked, it becomes two completely separate journeys. The only thing that it will help is if you're doing marketing along with it, you will then know whether you want foreign filings or not, because you will have to take patent timelines are hard in nature, So within 12 months, you will have to define foreign countries. Before that, you will have to define what is your inventive step. Then if you file PCT, another 18 months, you will have to define the countries that you want to practice in. And if you have not aligned those together, you will never be able to decide, or even if you have an investor, you will never be able to convince an investor of where and why you want to pay those fees. Let's say, and it starts becoming expensive. So if it's US, you would need to budget $5,000 for US. If it's Singapore, you need to budget another $5,000 for Singapore. So that is why that alignment is necessary, but it is not something that the patent office needs.
Okay. So, in your timeline, out of that 8 stages, if you will be helping in all the 8 stages. So you will be your team will be following all the 8 stages, or we should be behind you to do that.
It is us. No, it is us. It is us. Completely us.
Okay.
Our reminders go out 2 months before, and if you want to skip the timeline, then it has to come from you. But otherwise, it will be step 1. Then 2 months before the 12-month deadline, we will send you a reminder and we'll start working towards it automatically. And once we have tied up with an institute, basically, I mean, in maybe 2 or 3% of the cases, it happens where we file without any intervention. Sometimes professors leave or they get transferred, but then we have an obligation to complete it with whatever resources we have. So
you will be helping to have the direct patent granted
drafting
but granted by WIPO, you will be doing it, or national you will be doing and then go for WIPO?
Yes, I mean first will be Indian filing, and then you take a call. Now generally universities don't do foreign filings because the costs increase exorbitantly.
What is the difference in cost for national and international?
It's country wise again. So every country will cost you around $5,000 of that country. So if it's US, it's $5,000.
Okay, if it is directly filed in WIPO, will it cost? I heard that 14 lakhs it cost.
Irrespective whether it's direct or indirect, the cost per country is around $5,000 to $7,000 of that or currency of that country.
Okay. Okay, thank you. That's all my questions are.
Good afternoon, sir. I am Dr. Amit Sharma, Dean R&D. Actually, right now we are working on seismic performance assessment method for existing structures. So whether we should go for copyright or for patent?
If there is an instrument that you have developed which does that detection, then the instrument has to be patent protected. And even if it is not patent worthy, copyright is not going to give you any protection here. Because copyright will only protect the literary work, which means that people will just not be able to reproduce the content, but the idea can be manifested in a different way by somebody else. If the mechanism is unique, it has to go under either patents or design.
So it should be patent because it's a method basically.
Yeah. So it's a mechanical device or something like that, right? Yeah. So it will be a patent definitely. Copyright has got nothing to do with this.
Thank you.
A different type of question. Many times some technology is being used for a particular site, or rather we can say a solution for a particular site. That was the research of some person who had done it. Usually research is practiced in India, like that the same technology can be used for other site. Actually it is in the testing phase, and if it satisfies the norms, and that obviously the technology will remain same, but the solution will be different. So shall we go for patent in this type of condition?
Right. Theoretical answer is no. Theoretical answer, again, two answers here. Theoretical answer is no, because the Patent Act clearly states under Section 3 that a new application of a known technology is not patentable. But in my practical experience, it generally, even if you say that this is the same, it generally does not pan out that way. Almost always, when that same technology is used in a different field, you will modify some parameters or some ranges of that technology. And if that modification was not envisaged or thought about earlier, let's say you are taking a civil engineering application and using it biomedical. And now, because of that shift in civil, because in civil engineering, crudeness does not matter. But if the same technology is being applied to the human body, there you cannot have a margin of error at all. So now you are modifying that technology to make it suitable for a human body. So for that limited tweaks and modifications, you can get a patent for it. So that's the practical answer.
Obviously there are modifications because all the sites are different. So their responses are also different.
So yes, that's what.
The responses are different.
That has to be then clearly brought out in the patent application.
Okay, but it is
See how we took that. Yes, theoretically, again, if you ask this to the patent office, they will say no. He known tha, he don't do this.
Why I am asking this? Because this type of research is actually very common in India, and if we will be able to prove it, that is something different is there. Like for an example, we are dependent on surface and ground. I am water resource engineer, so I am giving example of water resource engineering. Suppose we are dependent on surface and groundwater at some site. Some site we are dependent on only on surface, some site we are dependent on only on ground. At some sites we are dependent on both. That is a combination. So we have to optimally design how much we depend on surface, how much we depend on ground. But why we depend on ground and why we depend on surface, the site, it depends upon the geology of that particular site.
Correct.
So geology will be different. So accordingly the solution will be different.
Right.
So
the term that you used, the optimal design, that allowed you to balance between these two resources can become a patent application. But then you will have to be very sure of how to make it broad, because in one scenario, the optimal range will be different in another scenario. So we need one.
Optimal range
so that definition will have to be very clear.
Obviously, it
So
will
we
be
need
different at different sites.
But then we cannot have multiple patent applications. No, our job is to have a broad patent application. So defining a least common denominator definition.
I got an idea from your presentation that for a particular project, you can file more than 100 patents in the process. So suppose a student is having a nice project, so he can file more than one patent.
Yes. They can.
If it is like this, if it will be clearly explained to them, I think faculties will be able to file the patents, or the students will be able to file the patents. They have to identify the thing which can be patented in their project. Okay.
So it starts from there only. You define the output first. This is an output that the world has not seen.
Yes.
And then that is the only job that you do as researchers or academicians inside. And then we start working backwards with us. Kaise hua? How did this happen?
Now my question is, I got the details, what exactly should be done. This I understand. My faculties are also able to understand. I think they understand up to a certain extent so that they can communicate or convey this message to the students. Now the question is, what will be the role of your INC-D? Like we should have a committee within the college, and they have to identify the things, and then the identified patents will be communicated to you, and then you will help us in granting in the whole process of granting the patent. This will be the way?
Yeah. So essentially, the core thing would be drafting the patent application. So converting whatever is in your head into a written format and extracting that out of the research. More often than not, people have invented, but they are not able to communicate. So getting that out of the researcher's brain is where we come in. And then everything else is the statutory procedure.
Yes. So what
Yeah.
is my question then? I think we have to identify some faculty who identify that this thing can be patented, and then we go for the further processing. Now the question is, it's a big challenge. Is we in our college we are not very much comfortable with all these things, and it is
Right,
new
right.
for many of us. So we need training to our faculty members so that they will be in the condition to identify the problem which can be sent for the patent. So
Okay, okay.
are the INCDs looking after the training of the faculties also?
Yes, yes. I mean, now this is this is the first step that comes under training. After this training, it is a physical interaction. That is one way of
Yes.
informal training.
Yes.
Yes, yes. Everything, as I said, we handhold wherever we work with.
Because I will if I will share your details to all my students and faculties, so there may be possibility that some garbage may come out. So we have to
Yeah, no
filter
problem.
out
No
of
problem
also,
at
na?
all.
So
Yeah, yeah.
for
That is where
filtration,
we will do all that. Yeah,
है ना?
yeah.
For
Everything.
filtration purpose, we need our team.
Yes.
That the same thing
Yeah.
you are following is COEP Pune also, na?
Yeah, yeah. Even my side, we don't take up projects where we know that this is going to meet a dead end. I will not file things that are going to meet a dead end.
That is
That much
okay.
assurance I can give you.
No.
Because
Actually,
no,
I
there
am
are so
trying to
many
reduce
colleges
your
in
load.
Pune.
I am trying to reduce your load. If you get 1,000 applications, hardly 10 are workable. So that means it's a pure wastage of time of your valuable time also, or our valuable
But
time.
other way around also, no, it's a motivation for money. There are colleges in Pune who have filed 100 patent applications. All of them are garbage. And now nothing can be done. They have just wasted money.
No, so
And the
I
attorney
want
has
to
fled.
optimize. No,
So,
I am trying to optimize my this thing, na.
we will also help in that,
Yes.
definitely. That's what
नहीं,
I'm
so
saying.
actually वही
Honestly,
है ना कि before sending for the patent, if we do sufficient homework, then the outcome will definitely
वो
optimize.
iterative ही है, but you know, once it starts coming, once those independent HODs or researchers starts interacting, then they will get to know कि अच्छा, you know, last time this will not go through and why it will not go through. So that's an iterative procedure over 1 or 2 years that will happen.
So as of my job, I have to identify one team in my college who will interact with you regarding all these things, right?
Yeah, that can be done, or independent professors can also, I mean, HODs can interact and, you know, it can
Obviously,
come to
HODs,
HODs.
it is
Yeah,
discipline
yes.
focus. Obviously, the team will be discipline focused because there may be possibility the requirement of higher technology may not be same as the requirement of computer science engineering. That I understand. So
Yeah,
their
yeah.
approach is different. Their type of submitting the proposal for patent is different. That I understand. But anyhow, we have to frame the committee. Then how frequently they can interact with you?
Anytime. There is no limitation on that at
Okay.
all.
Okay.
At all. I enjoy interacting with, you know, researchers and.
हाँ. I request Dr. Kothari sir to kindly elaborate. Yes.
Hello, sir. This is A.G. Kothari.
Hello.
I just would like to know what is the difference between patent published and patent granted.
Patent published does not mean anything, to be honest. Patent published is an automatic procedure. Even if you write poetry and submit it to the patent office, which has got nothing to do with science and technology, they will still publish it. Because they only start examining after they have published it. So patent publication has no value.
Unless it is granted, there is no meaning. Unless it is granted, there is. So there are some patents which are published from our college. So I'll share that list to you so that
Okay.
it can be further processed
I'll
for
sure,
examination
sure,
purpose. Right.
Sure.
And many of the patents are published. Yes.
Good afternoon, sir. This is Dr. Praveen Patel from Fire Engineering site. We have also one idea to enhance the capability of fire resistance time in the fabrics used by firemen while firefighting operation. So probably you have suggested many of the modes like process, machine, manufacturer, composition of matters. There are different ways to file that particular pattern. On which particular criteria we have to go for this? Whether
In
it is
this
for
case, it will be
the composition of matter, I can say.
Yeah, yeah.
So
Here it
composition
will
of
be
matter.
two things: either composition of matter or if it's fabric, sometimes it layers also, which
Yes,
is
of course.
technically composition, but it is layering also.
So composition of
So
matter may be the
composite
best
of that.
suitable
Yeah.
way through which we can
Yeah.
go. Okay,
Yes.
thank you.
Yes.
Thank you.
Anybody else?
Any more questions?
So I think everybody is thinking something in detail, and it takes time to come out of the thought process. So thank you very
So
much.
they can contact me anytime. They
I
can
will
email
share
me
your
anytime. We
details
will.
with everybody,
Yes, ma'am.
and we will come with some
Anytime.
strategy shortly. Within 2 days, we'll finalize what will be the way to identify the process and all, and how can they interact with you. Obviously, I will share these things to all heads and deans so that they can, or the professors also, so that anytime they can interact with you. And thank you very much. We are very eager to implement this because there are so many ideas with us, but we are not getting the right direction to publish it and also finally to patent should be granted. So we are trying to create an ecosystem for innovation and entrepreneurship. So it will be a great help from your side. Thank you very much. And I will have a detailed meeting with you regarding the financial details and all disbursement.
Yes.
Right?
Yes.
Thank you. Thank you
Yes.
very much. Thank you very
Thank
much.
you, everyone. An
Thank you
honor
very much.
to be.
Thank you.